want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have two cases to be argued. The first case, which I know the students had studied and found very interesting, I'm confident of that, had to be postponed because of the illness of one of the attorneys. So we have postponed that for further scheduling, and we're going to hear the other two cases. And after we complete the other two cases and adjourn court, the panel will confer with respect to the arguments, and then we intend to come back in the courtroom and conduct a question and answer session with the students, the faculty members, or whoever wants to attend. And at that time, the judges will answer some questions. But until then, we're going to have the lawyers answer questions. The first case that we'll hear, and then let me say one other thing. Judge Thacker and I are graduates of the College of Law at West Virginia University in Morgantown. Our distinguished colleague, Judge Motz, is a graduate of a wonderful law school down in the Old Dominion. And she should be presiding under our protocol today. But in exercising her seniority on the panel, she has ordered me to preside. And I am dutifully attempting to perform that. But the first case is John Doe versus Wallace Ho et al., number 18-1497. Mr. Schwartz. It's nice to have you here, and thank you for coming to Morgantown, sir.
Thank you. Good morning, Your Honors. Good morning, assembled. May it please the court, my name is Ron Schwartz, and I represent the plaintiff, John Doe. The plaintiff was a senior at the University of Maryland, almost ready to graduate, when he was expelled from the university for alleged sexual misconduct. And I've alleged basically, well, the complaint alleged three grounds: equal protection, due process, and Title IX reverse discrimination. But I'm focusing on the due process and the reverse discrimination case.
You're focusing on due process?
On due process and the Title IX reverse discrimination count, erroneous outcome claim under Title IX. Now, seems to me, and I've raised lots of due process arguments in my brief.
So what's your strongest due process
So
argument?
thank you, because I was just about to tell you that. My strongest due process arguments, I'm going to focus on 3 points. The first point is that there was a huge, the most important piece of exculpatory evidence, which was in the control and possession of the university, was not provided to my client. There was a handwritten statement that the alleged victim, Roe, wrote when she was interviewed by the police at about 6 in the morning. And in that handwritten statement, she described essentially a consensual sexual encounter with a person that she thought was somebody else. And
if she thought it was somebody else, how is it consensual as to your client?
well, that's the interesting, I mean.
Yeah, so what's the answer to that?
If you just give me 1 second, I will answer it.
I'd rather you just answer it now.
Okay, well, the answer is that there's a mistake of fact defense in this case.
Okay.
And it's a question of consent. Certainly can be under the sexual misconduct policy. Consent can be shown by actions. I mean, we don't need affirmative consent before something happens. So if somebody acts in a way that the person that's acting believes is consensual, and he reasonably believes that she knows that it's him, then he's acting without intent to commit any offense. And so the question is, is this a strict liability crime? I don't think it is. I mean, this is not a criminal case, but it is it's disciplinary. So I would call it.
He's lucky it's not a criminal case.
It wasn't a criminal case because the authorities believed it was not a criminal case.
Well, the authorities declined prosecution.
They looked at this immediately and said
that doesn't mean that he's not subject to expulsion by the university.
I agree, and there are different standards, and the standard of proof is different. There's many differences between the criminal but in the criminal law, there's a defense of mistake of fact, and this is a mistake. If you take the plaintiff's allegations as true, which you must at this stage of the complaint, then the plaintiff reasonably believed he had consent, and if it went on for 10 or 15 minutes, and there's verbal consent, he has a beard, he says they looked each other in the eye, they spoke, he had every reason to believe that there was consent. And this case turned, Your Honors, on his intent. I mean, he was expelled because the fact board, the SRC, the Standing Review Committee, found that he acted as a predator, that he went in with bad intent, but he was never given any opportunity to prove that. And the most important corroborating piece of evidence to his defense was withheld. And that was her
letter,
statement.
yeah. Where is that in the record, the letter?
The letter, it's JA 345.
Thank you.
It's her handwritten statement, which we only obtained.
Statement.
It's the handwritten statement. And it was only obtained by a subpoena after this case was filed. And I would point out.
Was it properly in the record?
Yes, well, it was attached to a motion to dismiss, and it was argued below. I argued it to the court. So yes, we didn't have it when we filed the complaint, but we obtained it. It was an attachment to a motion to dismiss, and I argued it below, and Judge Zinn has considered it. So it is part of the record in this case. And it was provided by the defense. I mean, the university provided it to me. It was from the university police.
Oh, I'm sorry. I thought you said it was withheld.
It was only given to me after I filed a subpoena after this case was filed. It was withheld at the time of the hearing.
It wasn't provided to your client.
It was not provided to my client.
Okay.
In connection with the hearing.
Correct.
And you're claiming that
Absolutely. It was
that impacts the due process issue.
Absolutely. And
Can I just go to the consent? What in this do you say indicates her consent that it was your client and not KP?
well,
I'm happy to have you refer to
clearly she did not know.
Well,
Clearly she did not know it was my client, but
well, but
okay, but
you can. Let's take it out of this hypothetical, and if a woman would consent to have some sort of relationship with her husband or her fiance, and some stranger came into the room and raped her, and she knew it wasn't them, just because she had consented to have the relationship with somebody doesn't mean she has consent for the world, does it?
No,
It doesn't.
It doesn't, but when you have, my client had a beard, okay? KP doesn't have a beard.
And you knew they knew all that at the due process hearing.
Well,
That he
my
had a
client,
beard.
my client did raise that he had a beard.
Yeah, he argued all that
He did argue
to
that
the university board.
he did argue that he had a beard at the but what he was not able to do, Your Honors, what he was not able to do, they didn't believe him, and the fact that the victim herself said,
We reweigh credibility issues.
well, there was no opportunity to assess credibility in this case, and that's part of the problem. I mean, we have two statements.
Did the victim testify?
Never. She never appeared. The only time the victim ever had to do anything in this case was have an interview with the investigator the day after the event. And the two statements, the statement she gave to the police and the statement in her own hand, which was not provided, and the statement that she gave to the investigator couldn't be more different.
Okay.
They described.
Where in the record is the statement that you say is different than the letter?
It's the Bronson statement. And it's Exhibit 5 to the complaint, and starts at JA 152.
Thank you.
152, 153, 154, through 157, and actually it's easier to read it
So what is the key difference between the statement in the police report and her handwritten statement?
Well,
What's
okay,
your,
her handwritten statement says the sexual activity went on for 10 to 15 minutes. In the statement of Bronson, it's 3 to 5. It's a big difference. Something's happening for 10 or 15 minutes. You know, when does a person reasonably believe he has consent? 10 to 15 minutes is a long time. 3 to 5 is much quicker. In the statement for Bronson, she said she drank a lot more. She said she drank a half a liter of wine. There's a question whether she was intoxicated or not. That is strongly contested in this case. In the statement with Bronson, she talks about a lot more drinking than she says to the police. In the statement to Bronson, she says that essentially he forced himself upon her and she just went along. The statement to the police is a very different statement. It's a statement of she thought it was her friend. She's describing essentially a consensual act that then when she realized it wasn't the right person, she says, "You're not KP." He's immediately shocked. He's surprised that she doesn't know. That's the important exculpatory piece. And he immediately stops. He says, "I'm sorry. Do you want me to get KP? I'll leave the room." So this is not a person that is acting. He believes that she knows with whom she's acting. And, you know, intent matters. And this case turned on intent.
Did you represent this person before the
I
university?
did not. He was unrepresented before the university.
Could he have had representation?
Could he have had representation? Yes. The cost of representation is basically prohibitive for most college
He was told more than once that he was entitled to have his own lawyer.
Let me say what he was
Is the
told.
answer to that correct?
He-
Right? He was advised he could get his lawyer.
No, he was never advised until 6 days before this. Now, there was a statement of rights.
6 days before what?
Well,
The hearing?
Excuse me. 6 days before the hearing, he asked for a continuance because the time between the charge and the hearing was 6 days.
When was he advised of his rights?
The original notice says you have a right to a lawyer. So I would say right in the
That was
beginning.
early on.
That was early on,
There
correct.
you go.
Correct. But in fairness, you know,
In fairness, he was advised he could have a lawyer.
he was advised he could
and he
have a
didn't
lawyer.
get a lawyer.
No, he didn't. He didn't tell his parents. A lot of these kids don't tell their parents. They don't understand the significance of it. I would like to do something about
Or
that.
he
but-
did understand the significance and that's why he didn't
Well,
tell
I
his
think he didn't
parents.
understand. No, what I would say to your honors is that he was under a pretty large misapprehension that because he was not charged criminally, he wasn't going to be in trouble. I think he really didn't understand the significance of it until the charge came down 6 days before the hearing. And then he's scrambling. And then he says to the director of student conduct, "I want to get a lawyer. Can I have a postponement? We're in the middle of final exams." He says, "I need a
And
postponement."
that was in May?
That was in May 6th.
Was that in the middle of final week?
It was, if it wasn't the middle, it was it was a couple days before
And
final.
he was a senior?
He was a senior, correct.
Was he going to graduate?
No,
that
he had a couple
semester?
more. He had a few credits shy. He would have had to come back for I think 4 or 6 credits. So he was not a graduating
Would he have
senior.
graduated in the summer?
He would have graduated in the summer or the next fall.
Okay.
He was a couple credits short. He wouldn't have graduated. It wouldn't have been the final thing. He would have been a few
But he
credits
said, "I'm going to
short.
be in final week, and I'd like to have a continuum."
Correct. 6 days.
And they denied the
They
continuum.
denied the
What
continuance.
was the reason for the denial?
The reason for there was no reason for the denial. The reason
didn't
says
give a reason?
there's no procedure for a continuance. That was the
Well,
answer.
how do we review that in the context of this case?
Well, because
How do we review it? What's our standard for review of the denial of the continuance?
so it is
What's
one.
the standard of review?
The standard of review is whether or not, as taken as a whole, there was a denial of due process. Due process looks at the gestalt of the proceeding, not one particular thing. So I don't think you need to make a rule that says you're entitled to continuance in a student misconduct
Standard of
case.
review is totality of the circumstances?
I would say
What
that
is-
Matthews versus Eldridge and all the due process cases say there's a flexible standard of due process, that you look at the case, you look at the matter as a whole, and you say, was a fair hearing given here? And
No, but on a denial of a continuance, if it was in it was in a district court and it came up
well,
here,
it would be an abuse of
discretion.
Correct.
And the abuse of discretion, the district judges or the trial judges have discretion on whether to grant continuances. Does that not have anything to do with this?
I agree, it has nothing to do with abuse of
Not
discretion.
having to do with it.
No, I don't. This is not a case where it's a question of a trial judge.
So we don't review that for discretion.
I don't think you review that for abuse of discretion. You look at the entire process and say, was it fair? It seems to me, and I don't want to give up my Title IX case because I have 2 minutes left here, but the standard of proof, Judge Zinnes said that if I had statistics, that might be a different story. And I say that that's an unreasonable burden. There are cases that say that Iqbal and Twombly don't make you have to make a prima facie case at the pleading stage. If this was a private school and I had a reverse discrimination case, I wouldn't be able to do a freedom of information request to get the statistics. These numbers are in the control of the university. My allegation...
This thing's up here on summary judgment?
It's up here on a denial of a motion to dismiss under 12b-6.
It's on
at the pleading
12b-6.
stage, correct.
So you claim that we got to give you the facts?
Absolutely, that I have at least some process of limited discovery. There's a great law review article that I found on this after the briefs were written. It's 85 Fordham Law Review 2665. It reviews all the cases under Title IX and the standard of pleading under Iqbal and Twombly. I commend that to you. It's a great article and it reviews the entire compendium, and it says that you need to get at least limited discovery at the pleading stage to get through that. But let me get back to the final due process argument in this case. Due process is for everybody. I mean, it well may be that if on a remand and my client gets some opportunity to test the credibility, which this case turned on. I mean, his intent mattered. And even if he was found guilty of a violation, he was expelled. So it doesn't just go to the violation itself, but also to the sanction. He was never able to test her allegations. He was never able to bring witnesses because he was convicted by a police report in this case. And there was no, the university will say, well, the rules talk about witnesses. They don't say that the respondent can bring witnesses.
So is it your position that he couldn't have brought the witnesses?
That is my position, that the procedures do not provide.
Is there something in the record in which
The
he
records
says
do
that
not-
he was told he could not bring witnesses?
Well, I will tell you there is something in the record.
Okay.
My client was provided with the wrong procedures.
I understand that.
And those procedures provided for a subpoena for witnesses to be issued by the Director of Student Conduct. This was on May 5th or May 6th. My client wrote the Director of Student Conduct the next day and said, I want the policemen to come to my hearing next week. I want a continuance, but I want to be able to subpoena the police officers. And the Director of Student Conduct wrote back to him, read the rules. And the rules don't provide for bringing witnesses. They talk obliquely that...
So if we send this back, you're not going to bring any witnesses?
I would. I would.
You just said the rules
Well,
don't.
the rules don't provide for it, and I think that you need to send it back and say you do need to bring witnesses. That's an essential element of due process. I can't believe that
Could he have brought affidavits from these witnesses?
Well, he brought statements, and they were not... They essentially... He brought 3 statements that said...
I'm asking if it's an affidavit. It's under oath?
They're not under oath.
They're not affidavits.
They're not affidavits. They're just statements.
But the rules of evidence don't apply in this
The
area.
rules of evidence...
They don't have to apply.
They don't have to be under oath, but...
They don't have to apply.
But the point of the matter is that the board compared a cold record of a police report with statements that my client got at the last minute and said, no, I never was contacted by the investigator. No, she wasn't drunk. I mean, they refuted some of the important facts, but they gave it no credibility. And they said it in their decision, we're not giving them any credibility, but credibility needs to be determined. You need to bring witnesses to assess that credibility.
Again, if we take it away from this particular case and you have witnesses, for example, to say you have a traffic accident and you have 3 witnesses that saw you 10 minutes before, they aren't helpful to what actually happened about who ran the red light, are they? No, they're witnesses.
But in this
But they're not witnesses to the operative important
But in this
fact.
case, they were witnesses to the intent. The intent
how could they be witnesses to
because
intent?
they said that my client entered this room on a dare. That's not what they said.
They were
That's
playing a
what the
trick on
police.
this-
That's what the police said. They said they recanted that testimony. They said that's not what they told the police, but that's in the police report. And the investigator says when my client raised the fact that they never talked to them, the investigator says at the hearing, well, there is the police report, and it's our belief that he didn't want to talk to them because he felt that he had what he needed. What we have done in this case is we have combined the evidence gathering, the relevance gathering, the prosecutorial function in one person of an investigator and who trains the panel that hears the case. And so you can't, that to me is a denial of due process, to combine those functions. Either he's a prosecutor or he's an arbiter of
Do
the
you know what
evidence.
that red light means?
Yes, I understand, Your Honor. I think I'm out of time.
Thank you.
Thank
You said you've reserved some time.
I reserved 5 minutes. Thank you.
Mr. Lord? Good to have you here, Mr. Lord.
Thank you very much. Good morning. May it please the court. My name is Christopher Lord. I'm an assistant attorney general representing the University of Maryland and the individual university officials who have been sued individually and in their official capacities in this case. Mr. Schwartz has stated in his argument multiple times that this case hinged on Mr. Doe's intent in entering the room. In this case,
Sounds to me like he's just saying it was a practical joke that went bad.
well,
No.
He's not saying?
that's what Mr. Doe originally said, and that is what his friends originally said. And now Mr. Doe went to the hearing and denied it and asked his friends to sign statements that said Mr. Doe wasn't aware that we were daring him. This witnesses.
What difference does the dare make?
Well, this is why it's important, and this goes right to due process, Your Honor. In this case, the SRC, the Standing Review Committee, heard the evidence from the report and decided, it did not decide whether or not Jean...
But it didn't really hear the evidence from the report because there weren't witnesses there. For example, why would he not have the opportunity to cross-examine the victim?
Well, in this case, the cross-examination would not have done anything, and here's why. The SRC did not decide the case on the basis that Mr. Schwartz is now arguing. It was not a question of whether or not Jane Roe consented to engage in sexual activity with KP, the person whose bed she was sleeping in, whom she had gone to bed with. KP got out of bed, Doe slips into bed. There's a question of his intent and why he did that, but it is undisputed that they engaged in sexual activity and that she, in fact, did not know she was in bed with Doe. The university...
Well, the police report says that all sex acts were consensual. What are we to do with that?
No. The police report said...
Looking right at it.
The police report concluded that the police said the evidence was that she was willing to engage in sexual activity with KP, not with Doe. And in fact, in her own handwritten statement, which Mr. Schwartz now says should have been produced to him because it's exculpatory, and I'm referring to JA 347.
Why wasn't it produced?
The investigator didn't have it. This was part of the University of Maryland Police Department criminal file. They produced the report to the Title IX
But it is
office.
exculpatory, isn't it?
It's not exculpatory, and here's why. The SRC did not decide the case on whether or not the act was consensual, the sexual activity was consensual. The university decided there was a policy violation because she did not consent to have sex with Doe. So in other words, she is having sexual activity with somebody she doesn't know. It's a dark room. She's gone to bed. She thinks she's in bed with KP. She wakes up and she's engaged in intimate sexual contact with somebody named Doe who she's not even aware she's in bed with. That fact is undisputed. Now the police, the dispute...
Well, that's your best case. I'm not quite sure that's right because remember there's the beard, or at least what your colleague on the other side says is that she did know that it was not KP.
Oh, no, Mr. Schwartz, and I'm
because
sure he
the
will...
beard,
I'm sure Mr. Schwartz will clarify that. He has never alleged that she, in fact, knew she was in bed with Mr. Doe.
Well, he said one of them had a beard. This guy had a beard.
Right.
Doe had a beard, and the guy that got out of
KP
bed,
did not.
KP
Right,
didn't have a beard.
Right, and so what he's...
That's a big difference.
Well, it's for two responses.
And there's referred in her statement to kissing.
You're correct, Your Honor.
Her first statement, the one that you all hid in his view,
Okay.
refers to kissing.
Your
Now,
Honor,
you can
there-
tell the difference if you're kissing somebody, whether they were clean shaven or had a beard.
Well, there are two responses. First, I want to make sure the record is crystal clear. Mr. Schwartz, is not alleging and has never alleged in this case that Doe.
Mr. Schwartz has just got in the case. He wasn't in it back there when you
Yeah,
all.
Well, fine.
that-
Mr. Doe.
All you had was a bunch of hearsay
Mr. Doe has never.
with no witnesses.
That's not
Okay,
accurate.
so
Your Honor.
Doe isn't alleging, finish your
Thank
sentence.
you, Your Honor. Mr. Doe is not alleging that Roe actually knew she was in bed with KP, with Doe. She
She knew she was in bed with KP.
She thought she was
She
in bed
thought
with
she was
KP.
in bed with KP.
And
And
his-
she was
But
in
she
bed with
ultimately
KP.
knew she wasn't because that's what all this happened.
Exactly. And as soon as she came awake and realized she was in bed with Doe and not KP, she exclaimed, "You're not KP, get out." He doesn't dispute that. He does not allege. It is he writes in his reply brief, it is uncontested that this was a case of mistaken identity.
Can you respond to his due process arguments, the fact that he apparently wasn't allowed to have witnesses or cross-examine the victim, and that this written statement came too late?
Yes, Your Honor, thank you. First, the SRC, it's important in a due process hearing to analyze what the decision of the university was.
What's this SRC stand
The
for?
Standing Review Committee.
What?
The Standing Review Committee.
Standing Review Committee.
Right. So
They're the ones that are making the decision on whether or not to throw him out of school.
they're the ones who made a recommendation. They made the factual determination and a sanction recommendation that he be expelled.
And who made the decision? The president of the university?
Ultimately, in this case, it was at that
But
time.
the Standing Review Committee is the main body that had this proceeding
Yes.
where they denied the continuance in the middle of final week.
Yes, but after 4 months of this process
Well,
going
they gave him
on.
notice, how many, 6 days before the hearing?
You understand? Mr. Doe
They
was,
gave him notice 6 days before the hearing, yes or no?
yes.
They gave him 6 notice, and they scheduled the hearing in the middle of final week.
I don't know whether it was final week that week or whether he was finishing.
Well, it was in early May.
It was in mid-May, and he was invited to come.
That smells to the heavens that you're having a hearing on something this important in the middle of final week, and you deny continuance to a senior in college.
He had chosen not to come to a meeting with the director of the Office of Student Conduct the day before. That's called an outcome hearing. So the process is.
I thought you said when you were beginning to answer us, and I know it's hard because the questions are coming fast and furious, but I thought you said just a second ago, this had been going on for months.
It had been. So
Okay,
he was,
so what didn't he participate in before? Was there anything that any other opportunity he had to put forth his case?
Yes, he had multiple opportunities. He was advised in writing in January that the university had started a sexual misconduct policy investigation. He was told in that writing that he had rights to an advisor, to a support person, to hire an attorney.
Is this the two different notices, the one wrong notice and the wrong? Okay.
No, this was in
When
January.
did that happen?
That happened on May 5th. So what happened was he's
May
advised.
5th?
Yes, on May 5th.
That's when you sent him the wrong set of rules?
No. Really?
The-
That late? It came
No,
after?
In late January, he's advised in writing that there's an investigation.
Yeah.
He's given a link to the rules, to the policies and procedures.
But you sent him
that
the
will-
wrong set of rules.
Not on that date. Not in
What
early
date
January.
did you send him the wrong rules?
On May 5th.
May
it
5th,
was
you
a-
sent him the wrong rules. And the
And
hearing
and
was-
it was
He had the
corrected on
right
May
rules
7th.
He had the right rules in January.
He had the right rule. He had
A
right.
link to the right rules.
He had a link to the right rules in January. He met with the investigator in February. He met again in April to review the draft report. He was able to make comments on the draft report. He was able to give the names of his witnesses that he wanted the investigator to interview. He was able to respond to all the statements in the draft report.
Did the investigator interview all his witnesses?
This is the one disputed fact. The witnesses claim now, Mr. Doe alleges, that the investigator never reached out. The investigator, in his report, writes that he reached out to the witnesses. They didn't respond. He testified to the Standing Review Committee that he had tried to reach out. And you have in the record an affidavit from the investigator, an affidavit that states that he did reach out. He called them and sent them 2 emails, and you have copies of the emails. They're in the record.
So can I ask you, could Mr. Doe, could he have brought witnesses to the
Yes, absolutely.
And what tells him that?
The policy, which is Appendix A of the University Sexual Misconduct Policy, and I would refer Your Honor to JA 193, which describes the SRC conference procedures. And that policy.
That's the right set of rules?
That is the right set of rules.
And was that never given to him?
It was given to him. He was provided a link to it in early January.
When was the wrong set of rules given to him?
On May 5th, and it was corrected on May 7th. And I would submit, Your Honor, that in its university.
Did the notice in January advise him that he could get representation?
It did, Your Honor. And that notice is attached to the, it's in the record at JA 485 and 486. And I can just show it to you. You'll see my highlights. In a big, bold letter, role of the support person, attorney, and non-attorney advisor. This is in the very first notice he received that he was under investigation. And he knew exactly what was going on. He had been questioned by the police the morning after this incident happened. There had already been a criminal investigation. This is a case where this victim...
And he knew at that point that the criminal investigation had been closed.
I don't know whether he knew that at that point or not. It did not go forward.
That's not in this record?
I assume, I don't know whether he knew it or not.
That's not in this record?
I'm not aware one. I don't think it's in the record. I don't know if there's an allegation.
We take, what's the record show? We take the facts in his favor.
No, I understand that.
On this appeal.
But
his favor. He gets the benefit of the facts.
I understand that, Your Honor.
Okay.
He gets the benefits of the facts, but to the extent there are documents which are integral to the complaint, they outweigh the complaint. And in this case, what I would urge you to look at, Your Honor, are the policies which you've attached to the complaint.
I'm just asking you what the facts show about that right now. I mean, you don't know.
I don't know whether he knew whether the criminal complaint had been dismissed or not. He knew that he'd been questioned the day after the incident. He knew that a month later he received a written notice of a sexual misconduct investigation. He knew he was interviewed.
He knew he was not hadn't been criminally charged.
He knew that he'd not been criminally charged as of that date.
We can agree on that point.
We can agree on that, Your Honor. The issue, let me just go to the crux of the due process argument if I can. In this case, the issue was, as Mr. Schwartz stated repeatedly in his oral argument, the question hinged on Mr. Doe's intent. The SRC allowed Mr. Doe to testify, both to pose questions to the investigator and exchange in a heated and an extensive questioning and answering session with the members of the Standing Review Committee. He presented all of these defenses. He presented his defenses as to why he did not intend to engage in non-consensual sexual activity with Ms. Rowe. The panel, a 5-member panel, of which there is no allegation of gender bias whatsoever against the 5 panel members, listened to his testimony. As Mr. Schwartz had conceded repeatedly in his oral argument, the question in this case hinged on his intent, on Doe's intent. Rowe's intent, Jane Rowe's intent, had nothing to do with it. She is asleep in KP's bed. There's nothing she could have testified to that would have impacted on John Doe's intent. The only person who knew John Doe's intent was John Doe. The SRC testified John Doe testified in person to the SRC commission. He tried to explain why he did not go in on a dare. He tried to explain why he thought she should have known it was him. The SRC is the panel that made the factual findings. Having heard his...
So he couldn't bring those witnesses in?
He could bring those witnesses, and I'm not sure if I answered your question before.
No, and I have the language I have here, and I don't know that it's exactly as clear as one might want, but it does talk about witnesses.
And not only that...
The SRC will meet with available witnesses. Is there an ability for someone in front of the SRC to subpoena witnesses? It doesn't sound like that.
Nor is there any allegation in this clip. Mr. Doe has never alleged that he attempted to bring the witnesses and he was rebuffed. The only allegation is that he asked a question about it in an email and there was no response. but he was able to produce witness
I
statements.
thought, and correct me if I'm wrong, you surely have a better grasp of the facts, but I thought that he had understood from one of the emails the misinformation that they would subpoena witnesses, that they would bring witnesses in. Is that wrong?
I don't think that's accurate. I
Okay.
think what he's arguing now is that he had asked a question about witnesses and didn't get a satisfactory answer. But he never requested that his roommates be able to come and testify in person. Not only do the procedures
But he
allow,
brought statements from them.
He brought
not
statements,
sworn statements, but statements.
signed statements, which the SRC accepted into evidence, considered, reviewed that against the other evidence in the record, including Doe's own testimony as to Doe's intent, and found him to be not credible. That is exactly the type of due process hearing which is sufficient under the Constitution. He had a full and fair opportunity to know what the charges were against him, to know what the evidence was against him, to respond to it at the investigation stage, and then to present a thorough argument to the SRC itself, including
Did they specify which facts he testified to that were not credited?
Yes, Your Honor, and I think that this
Did
I
they
would
explain why he was not credible on those facts?
Yes, he did, Your Honor, and
And where is that? in the
it
record?
is JA 567 is the notice.
567?
567. That is the notice of the SRC outcome, and it is critical that the panel, I would suggest, read the SRC decision, because the SRC decision is based on two primary findings. The first is that while masquerading as, and this is the finding, I'm quoting, while masquerading as KP, Doe made no reasonable attempt to identify himself to Roe, who had no reason to believe the person who began touching her was not the person she went to bed with. Similarly, the SRC concludes, quote, all sexual acts that occurred between Doe and Roe were without Roe's consent in the view of the SRC, as she was unaware that it was Doe she was performing these acts with and not KP. The SRC specifically found that there was a policy violation based on the fact that she did not know she was in bed and engaging in sexual activity with Doe. She did not consent. The policy, moreover, the SRC also considered Doe's statement as to his intent and whether or not he intended to go into this room on a dare, or whether it was an innocent, he just went into the room to go to sleep, which he now claims. Having heard his own testimony as to his intent, they specifically find him not credible, and the SRC uses that word. So having had a full and fair opportunity to present his own testimony as to his intent, the SRC simply did not believe him. This court case today does not hinge on whether or not there's sufficient evidence to support that factual finding, although I would submit there clearly was. This case is a question of due process. Was he entitled? Did he have an opportunity to understand the charges against him, to respond, to know what the witnesses were saying, and to present his side of the story? That is what the Fourth Circuit has held. Those are the elements of due process that this court has held are required in student misconduct cases. All of those elements were satisfied in this case.
So I have gathered from the papers that he was relying pretty heavily on the fact that he'd gotten incorrect information from the university and later corrected. And I just want to be sure, I had thought they had both happened back in the day. And you're telling me the correct information, or at least a link to it, as I understand it, didn't get the exact policy, but got a link to it.
That's correct, Your Honor. The Notice of Sexual Misconduct Investigation specifically identifies has a link to it, and on the second page,
And you're saying that was back in January?
it was January, correct,
Right.
Your Honor. It's
And
on
then
JA 485 and 486.
Okay, and then when did he get the incorrect?
On May 5th.
Did he get the actual policy sent to him, or did he get a different link?
I think the allegation is that it was an attachment to an email that
what I
the
think
old
too.
policy was
Yeah.
attached. And that was a mistake. That was a university official making a simple mistake, which was corrected 2 days later. What happened was he was invited to come to the outcome conference. So what happens is there's an investigation. The director of the Office of Student Conduct invites both parties in to say, here's what the investigator found, and here are the next
Is that
steps.
the conference where they denied the continuance?
It was in an email exchange because he
Is
chose
that the
not,
one
he
that
did
he
not
didn't
come.
come to?
He didn't even come to it.
Mm-hmm.
This person is being accused of sexually assaulting, has been accused of sexually assaulting.
Now, what was the date of that one?
May 5th or May 6th. He was invited on May 5th to come to a May 6th conference.
Okay,
He
and he didn't come.
He didn't come.
What was the conference or the meeting that where he asked for the continuance and he denied it?
That was in an email exchange in that day and the following day. So Ms. Andrea Goodwin, who's
He
who's
asked
one of
for
the
continuance,
defendants.
was denied, and he didn't come.
No, he didn't come to on May 5th, he's told, we're ready for the outcome conference. You've had an opportunity to review the draft report, you've commented on it, the investigation's complete, now there's an outcome conference. And at that point, if there's insufficient evidence for a finding, then you'll tell the parties it's not going to go any forward, or if it's a minor violation, there might be an agreement on a punishment. If it's a major violation like this one, it will be referred to the Standing Review Committee for a separate level of review. So it's not the investigator making the findings, it's the five-member panel. I see my time's
Go
up. Can I
ahead and
Thank
finish.
you.
I have a question too.
He declines to come, and as I mentioned to Judge Dennis below, I can represent, Ms. Goodwin tells me that is the only time in her history where a student facing expulsion
She
declines to
tells
come.
you, or is that in this record?
No, I put it on the record before the district court, so I'll tell you also. It's not in the papers.
So it's
well,
not
other
in
than
the record
transcript.
here.
It's in the transcript.
That's your testimony.
It's a representation to the court. So the
Well,
point
can
is,
we-
he declines to.
Are we allowed to consider that as in this? What you say, somebody told you?
Probably not. No, Your Honor.
So, okay. So, I'm sorry, I'm really interested in
Yes.
the chronology
Yes.
of this.
Thank you, Your
On
Honor.
May 5th, he's told that he can come to
The outcome conference.
and he
Declines
says,
to
I'm
come.
not coming,
Says,
or
"I'm not
just
coming.
doesn't show up?
I can't make it. Don, you didn't give me enough time to. I can't make it. I'm not coming.
Okay,
So then she sends him a letter on May 7th and says, since you didn't come,
okay, but so on May 5th, he'd also been sent the wrong instructions?
she attached to the letter.
Uh-huh, okay.
So there's an email that's sent to him with a letter saying you're coming. The outcome conference is tomorrow on May 6th, and also attached to that were the prior policies.
Right,
He doesn't show on May 6th.
but he responds to that?
He
and
says I can't come
Can't come, and doesn't go.
and doesn't come.
And this was during final week?
I don't know the exam schedule, Your Honor. I'm sure it was around the time the finals are. I'm not going to dispute that.
But it succeeded, as I understand it, this whole business started in January.
Started in January. Started in December when the
With
incident
his getting
occurred.
the correct information.
Right, exactly.
Okay.
And he's told in January, you're under investigation. Here are all your rights and responsibilities. Here are the policies that apply. Here are your rights to counsel, to a support
Right.
person, to an advisor. He meets with the investigator in February. He's interviewed. He gives the names of those witnesses. Now, Mr. Schwartz is going to argue, yes, but we've alleged the investigator never contacted
We
him.
understand
There's
the
a fact
record,
dispute on
what
that.
the record is on that.
He
yeah.
he reviews the draft investigation report, commented on it in April. He's invited to come on May 5th. He's invited to come to a meeting on May 6th to hear the outcome of the investigation. He declines to come. On May 7th, Ms. Goodwin sent him a follow-up letter saying, since you did not, and that's at JA 542, since you did not come, here's what will happen. You've been charged with a violation of the school's sexual misconduct policy. You will, the hearing will be on May 13th, and at such and such time. And it also says, at that hearing, that the SRC is a formal body composed of a combination of 5 students, faculty, and staff who are specially trained to hold conferences with all parties and any witnesses in order to review the information presented by the special investigator. So not only is he told in the policy, does the policy allow for him to witnesses? In the letter that's sent to him, he's told that the SRC will hear from witnesses.
And in that May 7th communication, he is sent the correct policy.
He
Is
sent
that
a-
right?
He's told, and he sent a link to the correct policy.
Was it,
But he'd already been sent that link. I just want to be sure of this, because I didn't think you'd got the link until the 7th, but you're telling me he had the link back in
January.
January.
Right, and
All right.
not only did he receive the link back in January, but the second page, which is the list of rights and responsibilities.
Yeah,
what page you looking for there?
It's JA 486.
All right.
right.
He is specifically told that complaints against students will be reviewed in accordance with the sexual misconduct policy, University's Code of Sexual Conduct, and Appendix A of the policy. It is Appendix A, which are the procedures that govern here.
And those were the correct ones.
And those are the correct ones. He's
Now,
told
was
that in
it-
January.
Did it explain, we sent you the wrong ones 2 days ago, but we're sending you the correct ones now?
This was
Talking
back
about
in
January.
January. He's
Well,
told
but
this.
I'm talking about May 7th.
I'm not.
Did it say we sent you the wrong procedures 2 days ago, but these are the correct ones?
I'm not. No,
We know now you've received 2 sets of procedures, one on May 5th, one on May 7th. The May 7th ones are correct, the May 5th ones are wrong. Did you ever tell them that?
Not in
Give 'em
that
that.
letter. Not.
Well,
I'm,
okay.
but actually he'd received, as I understand your representation, 3. He'd received some indicating the correct in January, the incorrect May 5th, the correct May 7th, with a covering letter of some sort which talked about,
the SRC process and SRC process, including his right to have witnesses. And there's no allegation. When you review the transcript of the SRC, he clearly knew what was going. He was prepared for the hearing. He had statements from his witnesses. He was prepared. He could argue and did. He had reviewed the police report, including the police statements of Jane Roe's statements to the police. He argued to the SRC why there was inconsistency between those police reports and her statement to Mr. Bronson, and why he thought it was relevant. He had a full and fair opportunity to say there are discrepancies here between what Jane Rose said. But the SRC
You know what that red light means too, don't you?
yes, but I kept to
I know you a little bit.
afterwards.
That's right. They're taking advantage of me.
Yeah.
Good.
Mr. Lord,
Good.
can I ask you one question before you sit down?
Yes.
Because your time has expired, as Judge King's quite correct. How many of these hearings does the university have a year? Not exact number, do we?
10 to 12 or so.
10 to 12, and it's, as I understood, that this board was a mixture of students and faculty?
Faculty and
And
staff.
is it consistent for the year, or does it change for each, or do we know?
It varies somewhat, but I think the thing to realize is, and the policies address this, is not every claim of sexual misconduct will go to the Standing Review Committee.
Well, and I
Oftentimes-
assume the Standing Review Committee isn't just doing sexual misconduct. Couldn't it be dealing with cheating or?
No.
This is all sexual
This
misconduct.
is specific to sexual misconduct, and
Okay.
that's the point. It is a specially trained board. These cases are very sensitive, and they deal with issues that have heightened degree of sensitivity compared to a cheating case or a vandalism case or smoking marijuana on campus or something like that. These are special procedures that are designed for these very sensitive, emotionally traumatic cases for all parties in these types of proceedings. Thank you very much.
Thank you, sir. Appreciate it very much. Mr. Swartz?
Thank you, Your Honors. Just a couple points. JA 185 says, the Title IX officer or designee may request the appearance of persons from the university community who can provide substantial relevant evidence. There is no procedure for the respondent to call witnesses. In fact,
Where are you now?
JA 185.
Well,
It's-
I read something, it was one of these references that you gave me, I think it was in the 3s, which does talk about calling
It
witnesses.
says that witnesses, they will hear from witnesses. It is an oblique reference that they can hear from witnesses, but there's nothing that
Is
says.
it your representation that your client tried to bring witnesses in and was not allowed to?
It's my representation that my client.
Can you answer my question? Then you can tell me.
The answer is
your
my
view.
client asked the director of student conduct to subpoena witnesses. She ignored him, and then he did not bring witnesses. That's my
And he
my
brought these
representation.
statements from his
And that
witnesses,
was under
right?
the wrong rules, which provide for subpoenas.
Okay, can I ask you something? Was the witnesses' statements, is it inconsistent with what their testimony would have been?
Completely. And I want to read this to you.
I just want to be sure you understood my question. Were the statements that his witnesses gave, that he presented, would those statements be inconsistent with the testimony that he wanted them to bring in? His
No,
witnesses,
it would have
his
been, it
statements.
would have been consistent with his testimony, but I want to read this to you because this is crucial. It's JA 212. The SRC did not find Doe's explanation for entering the room to get some sleep to be credible and gave more weight to the interviews conducted by the police of the occupants of the suite. These interviews alluded to Doe entering on a dare to get into bed with Rowe to essentially see how long he could masquerade as KP before Rowe realized. That's the police report.
But did the statements that were before the SRC that he brought, those are the statements where his witnesses recanted and said, oh, it wasn't a
They
dare.
recanted, and
So the SRC had that to consider,
yes,
as well as his testimony.
yes. Well, first of all, he could
So-
not. He couldn't testify to what they said. So,
Right.
but
Well, he said he didn't enter it on a dare.
he said he didn't enter on a dare. That they might have made
So
some
what
joking
more
reference, but
would he have presented then to the committee?
well, he could have.
They heard his testimony and he presented the statements and in response to Judge Meltz's question, the statements were what they would have testified to.
I think live testimony, Your Honor, would make all the difference in the world. You know,
And
this
that's
was
the only difference, is
Yes,
whether
yes,
you
like-
consider the statements, the hearsay statements,
he had.
which are admissible in this proceeding.
He had a few days to get something together, and during
had
finals,
until-
finals week.
So
He
the
got
charging-
notice in January.
Let me explain. In January, he got notice of an investigation. The investigation goes through this entire process where they presumably interview witnesses. Then, at some point in April, there's a draft report that he gets to look at and make oral comments about. Doesn't get a copy of the draft report. In no time anywhere is there a
He
copy
probably
given.
could have gotten one had he gone to the meeting he ignored.
The meeting says, so the rules say the director of student conduct shall contact the parties to schedule an outcome conference. So on one day, on the 5th of May, he says, appear tomorrow at an outcome conference. And he writes her the next day and says, I couldn't appear at this outcome conference because I had finals, I had group projects, I couldn't go. And so then she writes him the next day, but I want these witnesses, and at that email, she sent him the wrong procedures. It was an attachment. It wasn't a link. She sent the wrong procedures. She wrote, review the code of student conduct, which were the wrong procedures. That's the code of student conduct. He then asks to bring the police to the standing trial. She writes, it's not a trial. And there's no procedure for postponement. And then the next day, they send the formal charges, the 7th of May, setting up the conference for May 13th. So there's 6 days during finals week. He says, I want to go to the student aid lawyer. I don't have time. I want a postponement. There's no procedure for postponement. No, that's not true.
Can I just ask you about, you heard the representations by your colleague on the other side about the, where the record lies on the police investigation of his witnesses. Is that a fair characterization?
The police interviewed the witnesses at 6:30 in the morning. They came into the room, they interviewed the witnesses at 6:30 in the morning. They wrote their recitation in their report. And that's where it appears. It's from the interview at 6:30 in the morning. And my client said, they asked him, well, why would your client say something different? It's not a question that he can really answer.
So you have a gloss on what was said, but he's fairly represented what's in the record. Is that right?
That there was no criminal.
You heard, weren't you
Yes,
here?
the witnesses came.
We were
they
all here
interviewed-
together,
They
right?
were interviewed. Well, I may have not missed exactly what it represented, but the witnesses were interviewed at 6:30 in the morning, and their statements appear in the report. That's what's in the record.
And your client saw those statements?
He saw the police report. That's correct. That's why he brought opposing statements to refute it. That's correct. But what I'm saying to you is that having a live testimony.
Oh, and I'm sorry, the other piece of this that was represented to us was that there had been an effort to get a hold of your witnesses. And the investigator or somebody said that he tried to get a hold
And
of
my
those
witnesses
witnesses.
say
The
they
witnesses
never-
say they didn't, but they have filed an affidavit saying that they did.
And my witnesses.
That's the way the record lies, right?
And there's an affidavit from also a counter affidavit from my witnesses saying, no, they never contacted us. Here's a copy of my inbox. We never received
Were
these
they affidavits
emails.
or statements?
Affidavits in this case, part of the record. So there's affidavits and counter affidavits as to that. It's a factual dispute as to whether or not they were contacted by the investigator. It is an issue. There's counter affidavits refuting each other. I don't want to make this into a summary judgment case because it's not, but they raised it by affidavit, so there's a counter affidavit filed. But let me just say.
And that was all in front of the district court.
It was all in front of the.
And it was all in front of
She
the,
decided not to deal
board.
with it. She basically said, I'm
And
not.
that red light's back on.
Well,
Yeah,
I,
but I'm asking the questions.
I know you. Right it is.
I wanted,
So that was all in front of the district court. This all happened before.
this all was in front of the district court, the affidavits and the counter affidavits.
Okay.
I just wanted to say a couple,
But
if I
Judge
could
King
just
is
say.
quite
in rebut-
right. Your time is up too, so you should
But-
be summing up.
Well, I've been trying, but if I could
You
just.
know, let me just say one thing to you. You should be interested in what we want to know because we're the ones that are going to decide the case.
And I am.
So just saying I'm trying to do it, you know.
I would, if I could just
I'll
say
just
one
leave it at
thing, in summary, Matthews versus Eldridge says, and there was no Matthews versus Eldridge analysis in this case, says that first we have to take the private interest affected by the official action. Obviously, that is in favor of the student. Second, the risk of an erroneous deprivation of such interest through the procedures used and the probable value, if any, of additional or substitute procedural safeguards. And finally, the government's interest, including the function involved in the fiscal administrative burdens that the additional or substitute procedural requirements will entail. Well, Catherine Carroll, the director of the Title IX office, who built this house, who wrote these procedures, says the new
I thought
policy.
you said this was gonna be in summary, in
Yeah,
short.
this is it. She says.
You're
the
still
new
taking
pr-
advantage of me. That red light's been on. Been a long time.
Well,
ago.
she just says there are no
Judge
safeguards.
Motz didn't ask you what Matthews versus Eldridge said. We're familiar with Matthews versus
We
Eldridge.
actually have heard of Matthews versus
Yeah,
Eldridge.
no.
heard about
Well,
it
but
long.
she says
It's
there are
older
no
than we are.
procedural safeguards. JA 233.
I want to tell the students that one of the grand traditions of the Fourth Circuit is that after each oral argument, we, the members of the panel, come down and greet counsel. And then we return to the bench and we call the next case. And that's what we're going to do right now.